Remember the good old days of being a landlord? If you needed to get your property back and give the tenant notice, you just shot them a quick text or maybe sent them a quick letter. Gone are those days. Now, sending your tenant a notice to leave is like preparing a Supreme Court brief that has high stakes, high risk, high implications. You could not get your property back. Worse yet, you could get sued if you do it wrong. This is thanks to good old California's legislature and some of the cities in different counties of the state that have a patchwork of legal complexities of tenant protection ordinances that overlap, and it's just a mess. So because of these legal complexities, people like you are coming to channels like this to help learn how to do basic things like how to just give your tenant a notice to vacate. I'm gonna walk you through it from beginning to end. I'm gonna keep it simple, I'm gonna keep it relatable, and I'm gonna break the video down into 3 parts. The first is 4 questions you have to ask yourself before you can give your tenant a notice to vacate, because these are questions that need to set you up to which notice do you send and how do you send it and when do you send it, all sorts of things like that. Second is I'm gonna actually walk you through a real notice to vacate form, and I'm gonna go over some of the things that jump out at me, let you know issues we've had, and so just give you like the real boots on the ground way to fill out this notice and how to comply. And then lastly, third, I'm gonna give you the 3 biggest mistakes I see landlords make. We manage over 1,600 rental properties in Southern California, and we see the headaches. We see the real pain when people come to us, they did it wrong or they made some mistake, and I'm gonna help you avoid those. So my name is Steve Welty. I'm the CEO of Good Life Property Management. We operate in San Diego, Riverside, and Orange County. Our mission is to make owning rental property easy. If you get value from this video, please hit like. It helps us grow the channel and get more good information out like this to landlords like you. Quick legal disclaimer, I'm not an attorney, I'm just an experienced broker, over 15 years experience. Please consult your attorney for your specific case. So I get this question all the time. People call me up or they send me a text, hey Steve, can I give my tenant notice to vacate? This is blah, blah, blah. And I say, okay, first question, what type of lease do you have? Because you'd be surprised, you can't terminate a fixed term lease. So sometimes people don't know this, but if you have a lease that expires in a year, you can't, no matter what form you use, there is no form to basically nullify a lease agreement that the tenant is abiding by. So fixed term leases, you can't serve a notice to vacate. If you're on a month-to-month lease, otherwise known as a periodic tenancy, then you certainly can terminate, and that's what we're gonna cover mostly in this video. Now, one bonus tip, if you have a lease, sometimes you actually don't even need to give any notice to vacate at the end of the lease, but you'll wanna check your lease agreement, because many leases, like the California Association of Realtors lease, for example, basically says that the lease is from this date to this date, and on the end date, you need to move out unless the owner accepts rent from you or extends the lease in writing. But you always, even in that case, you never want to show up the day the lease expires and expect the property back. You want to be communicative with your tenant. If you plan to not let them renew, let them know up front and give them plenty of notice, because if you just refer back to your lease and say, hey, it's in my lease, a lot of tenants don't read the lease. They don't understand that they agreed in the fine print to move out at the end of the lease term. So it's just something to look out for in your lease agreement. First pro tip is your lease might not require you to give any notice at all. Now, there's a caveat, like you'll find out, if it falls under local or state rent control, then you do have laws to abide by, but we'll get more into that here in a bit. Okay, so question 2 is how long have they lived there? If they've lived there less than 1 year, you generally can give them a 30-day notice. If they've lived there more than 1 year, you have to give them a 60-day notice. Question 3, are they on Section 8? Are they getting any sort of government assistance? Because if they are, you have to give them 90 days notice. And question 4 is, where is your property located? If it's in the state of California, there's a good chance it could fall under AB 1482, the Tenant Protection Act. More on that in a bit. However, the local city you're in may have stricter rent control than even the state level. So it's important to know where your property is located so you can find out if it falls under rent control and you can abide by those specific laws. What cities have their own tenant protection ordinance that you need to be aware of? Well, we manage in San Diego, Riverside, and Orange counties. So in San Diego County, there's 2 main ones. There's San Diego City, and then there's Chula Vista at the moment. Now it's always changing, so make sure you check up for up to date if your city has one, but these are the ones as of today. Orange County, we have Santa Ana, Costa Mesa, Buena Park, and Laguna Beach. And then Riverside County, we have one in Palm Springs, California. So how do you know if your property falls under rent control? So let's start at the state level. You gotta know the Tenant Protection Act, otherwise known as AB 1482, passed in 2019. So there are some exemptions from this act. Namely, if you own a house or a condo that's not owned by a corporation or LLC owned by a corporate member or real estate investment trust, which is most people. If the property property is 15 years or newer. So they put this carve out to try to incentivize developers to not get rent control, not fall under rent control. Also duplexes where an owner lives in one unit and just rents one unit, that also does not fall under the Tenant Protection Act. Also single family owner occupied residence where they don't rent any more than 2 units. And lastly, if you rent just a room in your house and it has a shared kitchen, the Tenant Protection Act does not apply to you. All right, so let's review this notice of termination of tenancy together. So starting at the top, you want to put the tenant's names, and then you always want to put the street address, and then you need to check the box, or you need to know, depending on the form you use, does this property fall under the Tenant Protection Act? And you'll see there's yes it does, it is covered, or it's not covered. And so the California Association of Realtors form makes it really easy, because it's like if it is covered, you fill out paragraph 2. If it's not covered, you fill out paragraph 3. They try to make this really dumbed down for us realtors. All right, so number 2. So if it falls under the Tenant Protection Act, it has a nice reminder to please consult an attorney. And then it says, okay, 2A, your tenancy, if any, in the premises is terminated 60 days from the service of this notice, or whichever is later, for the following reason. Now, it has to be one of these just cause reasons. So a family member is moving in and it lists those specific types. The owner intends to withdraw the premises from the rental market. Number 3, the owner intends to demolish or substantially remodel, and they have permits, because it doesn't say it there, but that's in the additional terms. And then there's actually a separate form for that. And then 4, owner intends to comply with the order of a government agency or court regarding the habitability of the premises. That one's pretty rare. Okay, now we get into relocation fees. And this is where it's different per city. So you need to really know which law your property falls under and if there's a stricter local ordinance. So relocation fees, it talks about the tenant's entitled to 1 month's rent if it falls under the Tenant Protection Act. And then you have 2 options. You can waive their last month of rent, or it says here you can provide direct payment to the tenant within 15 calendar days of providing the notice. Now section B, you'll see this is for people where the tenants live there less than a year, because you can give a 30-day notice. Now only if all tenants have occupied the premises for less than 12 months, or at least one tenant has occupied the premises for less than 12 months, and no other tenant has occupied the property for 24 months or more. So if you detangle that, basically, if one tenant has lived there, let's say 1.5 years, but then they added a tenant, let's say 6 months ago, then technically you could give them 30-day notice. Because of all the crazy tenant protection ordinances, we strongly suggest giving as much notice as possible, like 60 days. Even if legally you could give them 30 days, you're just in a much better position if they challenge it. All right, so section 3 really dumbs it down again for us. So it says that if it's not subject to the Tenant Protection Act, okay, great, but you still have to give proper time frame. So if you've lived there over a year, 60 days notice, less than a year, 30 days notice, 90 days notice if they're on Section 8 or government assistance. So here's a bonus tip on D that a lot of people don't know, that if you go to sell your property and the purchaser fulfills all 6 of these things, it's a real purchaser, like a bona fide purchaser, not like, you're trying to game the system. The housing provider opened escrow. The escrow is within 120 days or fewer of the delivery of the notice. The title of the property is separately alienable from any other dwelling, like a single family home or condo, and the tenant has not previously been given a notice of termination of tenancy, then you can give a 30-day notice if you're selling your place, if all those conditions are met. But another pro tip, you can only give one 30-day notice. So like if you give a 30-day notice and your escrow falls out and then you withdraw the 30-day notice, you can't give another 30-day notice next time. You'd have to give a 60-day notice. So you can only use that 30-day notice once. So be aware of that if you're going to sell. All right, and then the last part of the notice just talks about the penalties if the tenant fails to move out, and then also gives them a right to reclaim abandoned personal property. This is something that must go in every notice to vacate, and then tells them how to contact you. And then number 6 is the most important, is delivery of notice, proof of service. So you're gonna print out at least 2 copies. You're gonna give 1 copy to the tenant. You're gonna knock on the door. Hopefully the tenant answers, you give them the copy. Or substituted service, like an adult that's there, you can give them the copy of the notice. Or if no one answers the door, you call it's called nail-in mail. You post it on the door and then you mail them a copy, first class mail. You can also do certified mail if you're like in another state and you can't serve it, but I don't recommend it. If you're looking to have service done on your property and you're not in the area, or you just really want to make sure you follow the law, you can hire an eviction attorney that specializes in notices to vacate and whatnot. They can have this served for you and save you some time, but certified mail is an option. Finally, 3 costly mistakes we've seen landlords make to avoid giving a notice to vacate. Number 1, retaliatory notices. This is when you don't like the tenant, they've been requesting too much maintenance, they're just kind of getting on your nerves, and so you're gonna serve them a notice because you're tired of them. That's called a retaliatory notice, and that can get you in big legal trouble. So you need actual reasons. Even if it's not required by the Tenant Protection Act, it's a good idea to have actual valid reasons of why you're giving tenant notice to vacate. Just make sure you have a legal reason. Legal reasons are like the tenant's being vulgar or very hard to work with. The tenant's not abiding by the lease. They've got numerous lease violations. They're always paying the rent late. They've damaged the property and they haven't fixed it and you've asked them to. And no, landlords, a tenant asking for maintenance regularly is not a valid reason, and the number 1 reason people claim retaliation, so be careful. The second biggest mistake is improper service, and it usually has to do with the proof of service part. So they might do the notice correctly and then they just mail it, or maybe they post it, but they don't keep their proof of service. Your proof of service should be the one thing you focus all of your energy on, because this is what you're gonna have to show the judge if the tenant doesn't move out and this goes to court. So you need to have that bottom part of the notice filled out properly. We see some owners fill it out in advance and like give that part to the tenant. Don't fill it out in advance because you don't know how you're going to serve it, right? You're going to knock on the door. They might answer, they might not answer. So it might be personal service, substitute service, or post and mail. And so just make sure that that part of your notice is filled out properly. And if you have any inkling that the tenant might be contentious around moving out, have it reviewed by an attorney after you serve it. So the third big mistake landlords make is not knowing the relocation assistance rules. So the state has 1 month's rent relocation assistance, but different cities have their own rules. Like San Diego has 2 months rent and then 3 months rent if it's a senior citizen. Other jurisdictions have 3 months rent. Some of them have reporting requirements to the local city. So make sure you know your local laws. And if you have any questions, give us a call. We're happy to help. Ending a lease in California, it's not impossible, but you need to be very precise. If you're ready to retire from self-management or just have some questions about this video, please schedule a call at the link below or give us a call. We're always happy to help. And if you got value from this video, please hit like and subscribe. It helps us grow the channel and helps us get this information out to more landlords just like you. Lastly, we put a link to our Housing Heroes newsletter where we send a weekly newsletter to landlords that keeps you up to date on all the changing laws so that you can be more empowered and save money, save time, and save headache. I'm Steve Welty, CEO of Good Life Property Management. Thank you for watching.